In the Supreme Court of India, a high-stakes legal challenge is underway regarding the constitutional validity of the Digital Personal Data Protection Act of 2023. Petitioners levy a severe accusation. They argue the statute establishes unbridled state surveillance and severely limits the transparency guaranteed by the Right to Information Act. To accurately assess these claims, we have to examine the historical legal landscape. Before 2017, Indian law provided no comprehensive framework for personal data, and the right to privacy lacked explicit constitutional protection. That baseline shifted with a unanimous 9-judge Supreme Court ruling in Puttaswamy 1. The decision cemented privacy as an irreducible fundamental right, directly protected under Articles 14, 19, and 21 of the Constitution. Critics evaluating the new DPDP Act are often looking through outdated, pre-Puttaswamy lenses, or attempting to measure the Indian law against strict European frameworks like the GDPR. The Foundation of Data Protection Professionals in India, or FDPPI, points out the flaw in this approach. Their core thesis is that the DPDP Act is deliberately not a GDPR clone. It utilizes a highly localized fiduciary model. Under this fiduciary approach, entities that determine the purpose and means of data processing are burdened with high common law-style duties of care, transparency, and good faith toward the individual. Using foreign templates to judge Indian law creates false constitutional conflicts. Validating the Act requires analyzing its unique, localized architecture. We can start with the most politically charged criticism: the claim that the DPDP Act destroys democratic transparency by amending Section 8(1)J of the Right to Information Act. Petitioners characterize this amendment as a blanket bar on releasing information. A close reading of the statutory scheme reveals a different reality. The unamended RTI regime suffered from a significant operational gap. It failed to address the collateral third-party data problem. Consider a routine case study. An RTI applicant seeks records to verify the disbursement of a public welfare scheme. The applicant's interest is entirely legitimate, but fulfilling that request requires handing over the names, health conditions, and bank details of thousands of innocent, unrepresented beneficiaries with no notice. Before 2017, the power to release this massive trove of collateral data rested with a single mid-level administrator at the first instance, the Public Information Officer. Post-Puttaswamy, weighing an RTI request against the collateral privacy of thousands triggers a constitutional proportionality test. The DPDP Act removes this burden from the PIO, relocating the decision upward to Section 8(2) appellate authorities and the Data Protection Board. To ensure accountability remains intact, the FDPPI offers a targeted interpretive solution. The term personal information should simply be defined to exclude the official names, emails, and governance contact information of public functionaries. The DPDPI Act institutionalizes a higher-level mechanism to protect the fundamental rights of unrepresented collateral third parties while maintaining the core transparency of the RTI. This brings us to the next major constitutional challenge: the exemptions granted for state and research processing under Section 17(1)(c) and 17(2)(a). The petitioners argue that these provisions grant the state sweeping, blank-check surveillance powers. Let's compare the DPDPI Act's Section 17(2)(a) with Article 19(2) of the Constitution. Both permit restrictions for state security and public order, but the Constitution adds decency, morality, and defamation. By omitting these, the DPDP Act restricts grounds much further. Under its purpose-based model, the Act also rejects identity-based carve-outs, common in other jurisdictions. Educational institutions, charitable organizations, and professional bodies like doctors and advocates receive no categorical carve-outs from data protection rules. This lack of identity-based carve-outs explains the specific controversy over why there is no categorical exemption for journalists. The Act uses a purpose-based model. A journalist conducting genuine investigative reporting is fully protected under the Section 17(2)(b) research exemption, provided their work doesn't result in decisions specifically targeting a data principle. By restricting state exemptions more tightly than the Constitution requires and relying on strict purpose-based rules, the DPDP Act provides concrete safeguards against unchecked surveillance. The final set of constitutional concerns targets Sections 33 and 36. focusing on allegations of unbridled executive discretion regarding penalties and government data requests. Section 33(1) authorizes the Data Protection Board to impose monetary penalties if it determines a breach is significant. Critics argue that the word significant is dangerously undefined, creating a loophole for arbitrary punishment. But significant is not a blank check. It is tethered directly to Section 33(2), which requires the board to evaluate the nature, gravity, and repetitive nature of a breach. This threshold restricts the board's power, legally preventing punitive actions for minor infractions. We see a similar structural limit in Section 36, which allows the central government to call for information from data fiduciaries. The criticism here ignores a crucial textual limitation written into the provision, for the purposes of this Act. This specific phrase restricts government requests solely to administrative and regulatory enforcement of the privacy law itself. It legally prohibits the use of this section for intelligence gathering or political surveillance. Viewed in its entirety, the DPDP Act employs a matrix of structured discretion and administrative guardrails to prevent arbitrary executive overreach. The perceived flaws in the DPDP Act emerge when it is read outside of its statutory context or the bounds of Indian constitutional law. If the text does present operational friction, the Supreme Court has an established legal mechanism to address it, the doctrine of reading down. Instead of deploying the nuclear option of wholesale invalidation, the court can issue precise interpretive guidance to preserve the legislative intent of the Act while protecting civil liberties. The court could implement practical fixes, like mandating that all RTI disclosures containing the public's data be anonymized or pseudonymized before release. It could add operational safeguards, requiring RTI applicants to furnish a written declaration of public interest and an indemnification undertaking when seeking unredacted personal data. Striking down the DPDP Act entirely carries massive consequences. Wholesale invalidation would plunge India's digital economy into a regulatory vacuum, cutting off the cross-border data flows that fuel global commerce. This vacuum would strip basic protection from over 1 billion data principles overnight. This act reflects over 10 years of legislative deliberation following the Puttaswamy ruling. Applying the doctrine of reading down protects India's standing as a reliable jurisdiction, while balancing the democratic necessity of transparency with the constitutional imperative of privacy.